Welcome back to another explainer. Today, we're totally decoding the preamble of the Indian Constitution, and we've tailored this specifically for your UPSC prep. We're going to break down its underlying philosophy, its core objectives, and of course, that absolutely fascinating legal history surrounding its amendability. So, let's just get right into it.
All right, here's our quick agenda for today. 1. Objectives of the preamble. 2. Significance and the soul. 3. Part of the Constitution. And 4. Amendability and basic structure. Section 1. Objectives of the preamble. The blueprint.
You know, the preamble really is the ultimate hub for the nation's goals. Branching straight out from that core authority of we the people, it literally defines India's character. It lays out those massive foundational principles like sovereignty, democracy, republic, and secularism. It's the starting point for everything else.
So let's break down that first major objective, which is justice. And the framers didn't just write justice and call it a day. They embraced 3 very distinct forms. First up, social justice. This means equal treatment across the board. Absolutely no discrimination based on caste or gender. Then economic justice, which is all about eliminating those glaring inequalities in wealth. And finally, political justice, implying that all citizens have equal political rights and, crucially, an equal voice in the government. Put them all together, and the whole idea is to secure a truly fair and equitable society.
Now, for your exams, it is super helpful to link these objectives back to their historical inspirations. Think about it like a global puzzle. That trifold ideal of justice we just talked about, social, economic, and political, that was directly inspired by the Russian Revolution of 1917. Contrast that with the other core objectives of the preamble, liberty, equality, and fraternity. Those were drawn straight out of the French Revolution between 1789 and 1799. It's honestly a perfect synthesis of global democratic thought uniquely tailored for India.
Section 2. Significance and the soul.
Okay, so a really crucial point to grasp is exactly how the Founding Fathers viewed this text. Drafting Committee member K.M. Munshi famously called the preamble the horoscope of our sovereign democratic republic. And you might wonder, why a horoscope? Well, he viewed it as a prophetic document, something that literally maps out the destiny and the fundamental values of the nation for generations to come.
Following up on that, we have another incredibly powerful assessment from Pundit Thakur Das Bhargava, who is another esteemed member of the Constituent Assembly. He actually stated, "It is the soul of the Constitution. It is a key to the Constitution. It is a jewel set in the Constitution." He also pointed out that it acts as a proper yardstick to measure the true worth of the Constitution. And look, these aren't just pretty poetic words. They signify that the preamble is the ultimate guiding light when we need to interpret the entire legal framework of the country.
Section 3. Part of the Constitution. The legal drama.
All right, let's get into the legal drama, because the Supreme Court's stance on this actually shifted dramatically over about 3.5 decades. Back in 1960, during the Berubari Union case, the court took the hardline stance that the preamble is not a part of the Constitution. But then, a total game-changer happened in the landmark 1973 Kesavananda Bharati case. The court completely reversed its opinion, declaring that yes, the preamble is a part of the Constitution. And this was massive because it officially opened the door for it to be amended. Finally, fast forward to 1995, the LIC of India case totally solidified this, confirming the preamble as an integral part of the Constitution once and for all.
Section 4. Amendability and basic structure. So, if it is a part of the Constitution, can Parliament actually change it? The answer is yes, but with an absolutely massive caveat. We have to talk about the basic structure doctrine. This is a legal principle born right out of that 1973 Kesavananda Bharati case. It dictates that while Parliament does have the power to amend the Constitution under Article 368, they cannot alter or destroy its fundamental features, the basic structure of the document. So because the preamble contains these basic features, sure, it can be amended, but its core foundational elements can never be stripped away.
And that brings us to a super high-yield fact for your studies. The preamble has actually only been amended exactly once. That happened in 1976 through the 42nd Constitutional Amendment Act. During that amendment, 3 vital words were injected straight into our constitutional identity: socialist, secular, and integrity. The Supreme Court looked at this and held the amendment to be completely valid. Why? Because it didn't destroy the basic structure. Instead, it just sought to clarify and strengthen it. All right, we're going to wrap up this explainer with a bit of a provocative question, just to spark some analytical thinking for your mains. If the preamble's provisions are non-justiciable, meaning, they can't be directly enforced in a court of law, how does it remain the ultimate judicial compass for the basic structure doctrine? I'll leave you to ponder the true power of this non-enforceable yet utterly foundational text. Definitely keep that in mind as you continue your revision. Thank you so much for learning with us today.